Again, I appreciate you being here this morning. I guess we all wish we didn't have to be here to talk about a subject that involves learning from the experience of difficult economic times, but be that as it may, we have had to deal with that as an industry. First of all, before I get too far, I would say there are copies of my slides, a handout on the chairs in the back. If you didn't get those, Colin may grab you some, raise your hand, or please feel free to pick up a set. Again, we all wish we didn't have to be here to talk about this subject, but we hope the situation is getting better, and we all know we're going to be raising pigs. Somebody will be raising pigs, and a contract is a big part of that, and has been for a number of years. And we've had, as Colin said, we've put some information out on contracting, and I guess what I was trying to do with this talk this morning, and I want to make it your talk. You ask me questions as you have them. I'll be glad to cover as much as I can, but I just, the old saying, only a fool learns only from experience, but I think the bigger fool doesn't learn from experience, and we've had some experience now with how does a contract work when things aren't going well. And we've had some good experience, some bad experience. My goal as an attorney working with producers with contracts, and for you as, and I know we have people on both sides of the contracts here. I do in any of these talks I give, I realize that there's always two parties to a contract, and I think both sides have to look at that contract now going forward, whether it's the same contract or whether you're entering into a new contract. What are the things we need to be looking at to maybe do differently or do the same? And some of the things we can't change. That's just a product of being in a business relationship. Sometimes you're going to have problems that you just have to work through, and there is no solution in the contract. But at any rate, we'll work through that. This morning, I want to start with that discussion in the slides. Then, I think, not really a topic that fits under the title, but a very important topic to talk about, and I have covered this in some of the other presentations. The 2008 Farm Bill established some federal law requirements for contracts, for swine and poultry contracts. And that was June 18th of 2008, those requirements went into effect for any contracts, basically any contract entered into or modified after that date. And there just hasn't been a whole lot of attention to those that I've seen. I know some of you working with your companies or the producers entering into the contract have seen some of these disclaimers and clauses that have to go in the contracts right now. But I want to cover that because it is my understanding that the Packers and Stockyards Administration is becoming more active in looking at contracts to make sure they have those clauses in there as required by federal law, and if they don't, they are looking at possible enforcement actions. So we want to cover that. That'll be kind of in the middle of the speech. And then towards the end of the talk, again, whatever you want me to cover, I'll be glad to do, but I want to talk about liens. And I know this is a subject where, again, you've got somebody, we've got people in this room on both sides of the issue, but liens are a part of doing business. If you borrow money from a bank or other financer, you are well aware that there's always a UCC1 filed. If you're a contract feeder, Iowa law provides the ability to file a lien to protect your right to payment. And if you're the person or company owning the pigs, you have a right to file a statement or a lien with the Iowa Secretary of State to protect your right and put the public on notice that those are your pigs in somebody else's buildings. And there's a South Dakota case from a few years ago that emphasized the importance of that. If you're a landlord, if you're renting out your hog buildings or farm ground, but sticking with the topic here today at Pork Congress, if you're renting out hog buildings, you have a right under Iowa law to file and claim a lien to get paid your rent, and the collateral would be the hogs that are in that building. So I want to cover that a little bit. And depending on time here, I want to pull up maybe some examples, take a look at how you look at the Secretary of State's website, maybe get into some of the details there. Again, I want to cover what you want to cover today, so be sure and ask questions as we go. I will be around afterwards. We don't have anybody in the room Pardon me. There is no one in the room right behind us. I know you have other things to do at Port Congress, but those of you that have individual questions, I'll be glad to sit down and visit with you. And I won't send you a bill either, unless you talk to me too long. Okay. Pardon me. With that, let's get moving. All right. I wanted to start out with kind of the end of a contract, and we'll work our way back. And I guess the reason I wanted to start here is, sticking with the title of the talk, what can we learn about contracts and learning from the experience of difficult economic times? Is my mic still working? Okay, sorry, it sounded a little different in the tone. Okay, so let's just take the situation where, as we all experienced in the last year or so, the economic situation changed drastically. That's the understatement of the year. And so maybe that contract, when people entered into it, things have changed and something just isn't working now, and one party is having trouble performing under the contract. Well, I don't care whether it's a production contract where somebody's feeding hogs in somebody else's buildings, or a wean pig purchase agreement where you're buying or selling wean pigs to somebody else, feeder pigs, etc. And maybe it sounds like I'm getting on a soapbox here and not talking about legal issues, but the thing I see time and time again is the failure to communicate that there is a problem, or there's a problem coming. And I know sometimes people don't want to, they try and hold out as long as they can, but I think in the work I've done with individual producers in contracts, if you see a problem coming, if you don't think you can fulfill the terms of the contract, if you can't pay for those pigs, or if you're the owner of the pigs and that payment you're paying to a contract producer to feed those pigs, if you think you need to adjust it, or something along those lines, I think the goal, or the key, is to sit down and talk as soon as you can and say, here's the deal. Now again, some people would say, well, I'd rather negotiate, that might weaken my negotiating position, etc. That's obviously up to you. But the problems I see are when one party gets surprised by the other one. And that's when often people say, well, I don't want to have to call a lawyer. I don't call a lawyer till I just have to, because yes, we lawyers charge money. But the best advice I can give you, whether you call a lawyer early on or not, the best advice I can give you is communicate, communicate, communicate. Just however you do that, let them know that you've got a problem coming and you're looking at ways to resolve that, and maybe there's something they can do to help you out. Okay? Oh, thank you. Maybe I'll... sorry if my coughing is causing any problem here. Been out in the cold maybe too much. Okay. But as I point out here in the second bullet point, I think the key is to know your legal options before the negotiation begins. First of all, take a close look at the contract, but also know what happens when one party can't perform. If the other party is talking to you and saying, hey, I'm not going to be able to do what the contract says, what are your legal options before you get too far into the communication? Then if the negotiation doesn't work, you have to be ready to use your legal options. But what I've seen in the last year or so, those that sit down and talk, try and communicate the best they can. Often the legal options don't have to be used. And then the final bullet point there is don't give up, never give up a negotiation. Keep trying to work it out, even if you've started the legal process or it's been started against you. Please don't give up a negotiation. Any of you who have worked with attorneys or the legal process know that by far the majority of the cases never end up going to court. They usually get resolved at some point. So just don't think because a lawyer or the legal process is involved that you give up a negotiation. Okay, next slide. One of the big issues we've seen discussed in the last year or so is what's called a force majeure clause. And I probably butchered how you're supposed to say that, but that's as close as I can come. And it's called, almost all contracts, and maybe I need to stop there a second. One of the questions I often get is, well, they just can't do that. The other side just can't do that. They can't do whatever it is, and many people believe there's some higher being out there or law that says what a contract can have in it and what it can't. And in general, there are some parts of the law where the legislature has stepped in and said, here's what you have to do under a contract. But in general, a contract is whatever you and I agree to. And so if you have to look at the contract itself, and a force majeure clause, an example here. You have to read what the contract says. There is no general law that says this can be done or this can't be done. What are the words on the paper? That's where you start, and that's why it's so important, as we're going to talk about, working very hard to make sure those words on paper reflect what both of you want done. So, this force majeure issue has come up. When we hit the economic times we hit this summer, I started hearing, well, for several reasons. One of the things I think you all heard about was there was a question when H1N1 hit in April, and it caused the market to take the extreme dive it took. Then the question was, is that event, the fact that H1N1 hit the news, etc., was that a force majeure clause that would allow one party to the contract to not have to perform? And again, I'll use lawyer language here. In general, no, I don't believe it is, because the courts are very tough on what is impossibility of performance. Notice the word is impossibility. And some of the examples you've all seen in your contracts is fire, storm, government intervention, etc. One of the classic examples of a force majeure clause is when you have you're feeding hogs for someone else and your building burns down. That's a classic example of your impossibility to perform because your building just burned down. Often the clause says that you have an obligation to rebuild, but you aren't held to your contract until you're able to get your building up again and you're able to take pigs and resume performance under the contract. Tornado, etc. Those are your classic examples of what a force majeure clause is intended to protect people from. But what we see the two clauses and the provisions in these clauses I see that are normally accepted out are market forces, as you can see on the slide, and disease. Many contracts specifically say market conditions and disease, herd health, are not considered force majeure clauses. So, again, you have to look at what your contract says. Then we look at, as I have on the slides, we have the point, is government regulation, such a few years ago, one of the examples I saw was the situation with Canada and the tariff, and there were cases that I talked to producers about where the party to the contract said, well, I can't perform because of a government regulation here. Again, you just have to look at those specific instances. I can't give you general examples here. Price of feed inputs is another. We get the question. When corn went up, way up a couple years ago, the question I was getting is, hey, corn's went up so high, is that considered a force majeure clause that I am excused from performance? Also, what if the inability to get financing? If the bank or the financer is saying, look, I don't care what kind of contract you have, if you can't show me a profit here that you're going to be able to make money in those pigs, I'm not loaning you the money. Does that excuse you from performance under the contract? The basic legal standard, as I have here on the slides, is economically burdensome. Okay? And those are just a general term I'm using there, is usually not enough. When it comes to getting out of a contract under a force majeure clause, the courts are usually pretty tough, pretty strict, and look at it. Come back to the words at the top of the slide. It has to be an impossibility of performance. Any questions on that? Because I know there was a lot of discussion flying around out there last summer about that. Is about exactly how does that contract clause work. Now, let's look forward. If you had an experience with that, and now you're looking at a new contract or amending your contract, take a look at that clause and see what needs to be in there, what needs to be taken out, what examples do you need to have. Let's take a look at what we had to deal with last summer and see how we can write a contract better going forward. All right, if you learn that the other party to a contract, your question is, will they default? What can you do? You get a little nervous if the other party, you're concerned that they're not going to go forward with the contract. There is a provision in the law, and this is under the Uniform Commercial Code, so I am talking about a law here that applies to contracts, whether your contract provides it or not. You can demand that the other party provide you with what's called written assurance that they can perform under the contract. Again, the law calls it adequate assurance of performance. So, if you need to plan ahead, you need to plan for financing, and you're not sure the other party is going to be able to live up to the contract, you can demand or a letter through your attorney that they provide you with adequate assurance of performance, and if they don't provide you with that, pardon me, within a reasonable time, and the Uniform Commercial Code says not to exceed 30 days, then if they don't provide you with that assurance, then the law says that you have the right to terminate the contract, okay? And maybe look elsewhere so that you don't have to wait on them so that you can plan ahead, I guess is the best way for me to say it. Now again, with all these things, as I've laid out here, I would encourage you, this is not the kind of thing you want to handle yourself, in my opinion. You need to work with an attorney here. I'm not here to encourage you to just go find attorneys, but a lot of these things are obviously very detailed under the law. I'm just trying to give you an overview here because it depends on the individual situations. There are exceptions to everything I'm talking about as to whether they respond or don't respond, whether you did the right thing in sending the demand, etc. So, yes? The question was, couldn't there be some endless debate about whether the assurance is adequate? Absolutely. It's if the other party demands it and an answer is given, is that enough? That unfortunately is where the legal process comes in. But in general, you know, that's the process. Well, I guess what I'm trying to say here, the process gives you an option to at least try and find out what's going on. If you don't do anything, if you don't send that demand, then you haven't at least tried. There are always going to be details and facts as to what was the proper demand, what was the proper response, and again, hopefully all this comes back to continuing negotiation to try and get things worked out without involving lawyers in the legal process. Okay? If there is a default in the contract, almost every contract and the Uniform Commercial Code provides the right to cure any default. So if there's been a default in the contract, almost all contracts will give the other party so many days to correct it or cure it before the contract can be terminated. Again, you want to get the proper notice sent out that if there was a default, give them the notice that the contract requires so that if they don't correct it, then you can move forward with either terminating the contract or, again, I come back to it, keep the negotiations going. The third bullet point there is something I think peculiar to Iowa law. It's mediation is required by Iowa law for livestock care and feeding contracts, the production contracts. Before any lawsuit can be filed, there must at least be mediation offered, and I think this is a valuable part of Iowa law that, again, tries to get people together to talk about this. Is required under Iowa law for production contracts only, not for sales contracts such as wean pig purchase agreements, etc. Take another look at your contract then. Is arbitration required by the contract? Which state law applies under the contract? If there is a court action, where will the lawsuit or the arbitration be held? And then I want to talk just briefly about mitigation of damages. This is one of the issues that I probably get, not the most, but a lot of questions on. If the other party to the contract says, I can't perform, I'm walking away, whatever, what are you going to get if you do take them to court and you get a judgment against them? You will get money damages, a certain amount of money for their breach of contract. But you, the party who has not breached the contract, have an obligation under the court system to do your best to mitigate damages. That is, go find somebody else to put pigs in your building, or go find a source of pigs somewhere else, or go find a place to sell your pigs somewhere else. You can't just sit back, do nothing, and say, I'm going to collect all these damages from the other party. You have to do your best to mitigate or lessen those damages that you will be seeking from the other party. So, again, it's a critical issue. One, you want to do that anyway to obviously help your cash flow, and two, the courts require it. The damages that we usually see under a contract default, of course, the money damages. That's what courts always come back to is, okay, how were you harmed? How much money did you lose by the other party's default? Another question I often get is, well, I want the other party to be required to perform under the contract. I don't want to have to go find someone else. I don't want to, I like this contract, I want to work with them, and I just want them to do what they said they would do in the contract. Courts rarely order another party to a contract to stay in the contract. Courts don't like to be involved in ongoing orders and contract performance. They want to handle a set of facts, decide who owes what for money, get it done, issue an order, and then be done with it. So if they get into specific performance, that requires them to oversee two parties' performance under contract, and they don't usually do that. Again, it's extremely rare. I want to specifically talk about pig purchase agreements just for a minute. The damages for default under a pig purchase agreement is normally, normally this is provided in the contract, but it is also stated in the Uniform Commercial Code that it's the difference in sale price between what was under the contract and what you were able to sell those pigs out in the open market at the time of the default, plus expenses of the sale. Sale after the default must be in a commercially reasonable manner, notifying the defaulting buyer before the sale to the new buyer. In other words, somebody you have a sow unit and the buyer has notified you, I'm not buying that next group of pigs. Okay, there's a process you have to go through. And again, I would urge anyone in this situation, work with an attorney on this process. But yes, you will need to sell those pigs somewhere else if the buyer can't take them. But you need to notify that buyer that you are going to be selling them somewhere else. And you have to sell them in a commercially reasonable manner. And that is, get the best price you can with what's out there. Okay? And then the lawsuit would be filed for the difference in the price that you would have gotten under the contract versus what you're able to get. Termination of a contract. Another question I often get is, okay, they missed one payment. I'm done. I don't want to have to deal with this anymore. I want to terminate that contract. You got to be careful here. Termination of a contract, it can only be done, the courts have ruled, again, we're looking at the Uniform Commercial Code here primarily, if it has to be a material default, and that is defined as a substantial part of the contract, or if the default substantially defeats the purpose of a contract. So, if the default is not material, not a total breach, if it's and I state down here, the third bullet point down, for less than a total default, if the terminating party is in default of the contract, I guess back up to the second bullet point, if it's less than a total default, what I'm trying to say is, and you terminate because they missed a payment, you're going to be the one in default, not them. Because the courts will say you have the right to go after them for the damages for their failure to pay, but maybe they were able to come up with the money and buy the next group of pigs. You would therefore not have the right to terminate just because they missed one payment out of a multi-group contract. That's the bullet point I have here on this slide. And I say the second bullet point I have there, likewise, in general, under a production contract, missing one payment. If someone else is feeding pigs in your building and they miss a payment, it was due the 10th of the month and they don't make the payment on that date, if you try to terminate the contract for missing that one payment, in general, most courts would say you don't have the right to do that because that's not a total and material default. This comes as a surprise to a lot of people, but I think it's a key point we need to understand so that you're not the one that is found in default under the contract. Okay, I want to stop there a second. I've kind of covered, here's what I saw happen, a lot of the defaults we saw last summer, and I know we've had at least one question here. Any discussion there? Now I'd like to move forward into what can we learn from this? What can we look at in entering into or modifying a contract? That is, if you had a contract and the contract was terminated, you're looking at entering into a new one, or if you're modifying the contract you currently have, let's take a look at what should you be looking at differently than you did before. The first bullet point, I don't mean to insult anyone by putting that there, but you'd be surprised how many times when I'm working with people on a contract, it becomes apparent as we work through some of the problems in that contract that they did not read and they did not fully understand it before they entered into it. I know we're all busy, and you've got pigs coming into that building under this new contract, and you need to get the contract signed, and you've talked to the person who you're going to be entering into the contract with, and you're pretty sure you understand the terms. But it is absolutely critical you sit down with that contract and read it yourself. Go through it. Some people will say, well, I'll have my lawyer read it. My lawyer will explain it to me. That's great. But you need to understand that contract. You need to read through it and make sure you understand what it says. And if you don't, ask questions of the other party and ask questions of your attorney who is reviewing it for you. Know what is required of you. Again, I know this is pretty basic, but many times we get into a problem under a contract, and what happens is the person who is all at once you're being told you defaulted under a contract, and you say, I didn't know I was supposed to do that, but there it is. It's in the contract. Know what is required of you, and you know, if you have to, make a list yourself. If that contract's full of legal language you're having a hard time following, make a list yourself and make a list of key things you need to do at certain points in the contract. The ones that really catch people are the ones you don't have to do all the time. So, again, it's just critical to sit down, keep that contract handy. I know I'm probably, not many of you keep that contract under your pillow at night, I'm sure, but you've got to keep that handy. You've got to keep a copy out in the hog building. If there's questions that come up, look at the contract first. I state here in the bullet points, if it is in the contract, you must do it. If it isn't in the contract, it isn't part of the agreement. If you were told something when you were entering into the contract by the other party, and it isn't in the contract, before you sign it, put it in the contract. Anything that you've had discussions, verbal discussions, I want to see in that contract. Okay? Can we enforce verbal agreements? Yes. I think that's on the next slide. You can enforce them, but it's very, very difficult because it's a question of who said what. And any amendments or changes to the contract, usually these contracts will say it must be in writing and attached to the agreement. So verbal discussions, I know again, we're all busy, and maybe partway through the contract you figure out, well, we want to do it a little differently, so let's do it this way. You both agree to it. It is, again, critical to write it down, both of you sign it, attach it to the contract. That way there will be no questions later on. Here the slide I have is oral agreements are binding in most cases. Again, the problem is proving them, as I note there, and quite honestly, it's just hard to remember what you agreed to if it's not in writing. I've already talked about this provision most written agreements have. It's called an integration clause that says the only thing that's binding is what's in writing. Any prior negotiations or discussions between the parties are not binding. So if you're relying on an oral statement somebody made to you, whichever side of the contract you're on, then if a problem occurs, the other party is likely to pull out that contract and say, look, here it says everything has to be in writing. I note here that everything is negotiable, including whether to sign the contract. And that's not a fair statement, really, at least the first part of that. Sometimes a part of the contract is not negotiable. The other party will say, look, it's either take it or leave it. That has to be there. Well, that's when the second part of my statement there comes in. If it's that important to you, then don't sign the contract. And that's why it's important to have these discussions early on in the process before you're in a jam time-wise to get the pigs in the building or to get the pigs sold, etc. And I know it might be easy for me to stand here and say, just don't sign it. You've got bills to pay. You've got a loan on the facility. But you need to, you just need to look at it and make your decisions about, is this a good enough deal that I want to sign this contract? If you have to do it, then you at least need to know what are those parts of the contract that I don't like, and at least you're going into it with your eyes wide open then. I've talked about having the contracts reviewed. We've already talked about that quite a bit. And then my fourth bullet point there is what I just talked about. Even if the other party will not change a term, at least you know what the interpretation is and you know what to expect as you work your way through the contract. And make it clear that there is no agreement between any of you involved in these negotiations until it's signed by everyone involved. Okay. I guess that I've pretty well worked through my part of the presentation there on how to negotiate, how to deal with default, etc. I've tried to give you some of the examples I've seen. Most of what I saw in the last year or so when contracts were in trouble all involved ability to make payment. After the market situation we went through in the last year, that shouldn't surprise anyone. Other times, when it's not economic conditions, probably the biggest dispute area I see is with pig health. That's on a wean pig purchase agreement. That's often the biggest stumbling block. You have a PRRS outbreak, etc. Those are usually the biggest issues I see where there are disputes in a contract. Now, when we're in good economic times, sometimes you see what if you've been the party that's agreed to purchase pigs for a certain price, and or I'm sorry, I said it wrong. You're the one selling the pigs. We hit good economic times, and there's a much better price out there somewhere else. Then you start seeing people say, well, maybe there's a way I can get out of this contract and find someone else. Flip that around. When prices are down, the party buying the pigs thinks, hey, I can buy some pigs somewhere else a lot cheaper than this. When you get into situations like that, that's where a strong written agreement is your best defense to say, look, here's what we all agreed to, and courts take a very, very dim view of someone trying to get out of a contract for reasons what they see as economic gain. Under the pretext of there's a default in the contract, if a court sees that you have an economic incentive to get out of the contract and you may be using a clause in the contract to try and do that, I've read numerous court decisions where the court saw right through that and took a very tough approach towards the person doing that. So with that, again, if there's any questions, I'll be glad to take them. I want to move now into the Packers and Stockyards Act requirements. As you're looking at entering into a new contract or modifying an existing contract, please take a close look at these. I mentioned this briefly in the beginning. This is, as you can see at the top of the slide, this is a result of a law passed, the Farm Bill, June 18th of 2008. And that Farm Bill was, thousands of pages, I believe, and this was stuck in the middle of it. But it is a part of the law now under Packers and Stockyards Administration, and I know some of you are aware of it. Many of you are. We had an article in the Iowa Pork Producer magazine last summer, I believe the July issue, where we went into a lot of detail. So if you need to take another look at this, go to the Iowa Pork website, iowapork.org, and they have the magazines there. And I'm pretty sure it was the July issue. If you have any trouble finding it, let me know. Here's the situation. The Packers and Stockyards Administration now is looking at both production contracts where someone is feeding someone else's pigs in that someone's buildings. They're also looking at marketing contracts, and in some cases looking at wean pig contracts for some of these provisions. And if the Packers and Stockyards Administration doesn't see some of these provisions I'm going to talk about here in a minute, there are possible enforcement actions for not including those for contracts entered into or modified after June 18th of '08. So even if you have a contract out there now that isn't subject to this, it was entered into in '06 or '07 or whatever, as you look at modifying those or entering into new ones going forward, you need to pay attention to these requirements. The first one that has to be in every production contract, and these are swine and poultry, is the right to cancel. The federal law now says that the contract has to give the contract producer 3 business days to cancel. It's the later of 3 business days or any date stated in the contract. So you can obviously give them longer if you want, if you're the one that's writing the contract. The contract must clearly disclose this right on the, I say on the first page, it must say it on the first page, and the method and deadline for canceling. The other thing that production contracts have to have is the disclosure of additional capital investments. What the law says is on the first page it must say that additional large capital investments may be required. Now let's stop there a second. When I first read this law in '08, I thought, okay, if you aren't going to require additional large capital investments, then there's no definition of what large is. If you're the person that owns the pigs and you're entering into contract with someone to feed those pigs in their buildings, the law says that you need to have a disclosure statement on there about additional large capital investments. Well, my thought was, well, if I'm not going to require it, and if nowhere in the contract says they have to make additional investments in their buildings, wouldn't need the disclosure statement. Packers and Stockyards Administration is not reading it that way. They're reading the law to say that you have to have that statement there no matter what. The law says you have to tell them there may be additional large capital investments required, even if the contract doesn't say that they may be required. So what's happened here is, giving an example, I worked on a contract for a client of mine. I put this statement in there. The other party to the contract called and said, what the blankety blank is going on? What's this about me having to pay for additional large capital investments? And we said, you don't. There's nothing in the contract. This is simply a requirement of federal law. I don't blame them. I would have been concerned to read that in there too. But the law requires this statement to be in there as well as the 3-day right to cancel. Again, if this is not in the contract for a contract entered into or modified after June 18th of '08, it's a violation of Packers and Stockyards Act. And my understanding is they're looking for contracts, they're reviewing contracts through the Packers and Stockyards Administration, and when they find contracts that don't meet these requirements, they're considering enforcement action. They're not taking a position of just saying, okay, hey, you got a problem here, you need to change it. Don't know exactly what will happen in the future with how those enforcement actions what will result from those, and we hope that they'll give producers some leeway here because this is a new law and some of these requirements are fairly technical, but we're going to try and get the word out again, we being Iowa Pork Producers Association, National Pork Producers Council, to people in this situation of what needs to be in a contract and what you need to do to hopefully avoid enforcement action by the Packers and Stockyards Administration. Pardon me? The question was, which party is that designed to protect? I believe the intent of the law would be to protect the contract producer by giving the contract producer 3 days to cancel, and by giving the other provision there, the additional large capital investments, by protecting the contract producer from being forced to spend money later on in the contract that they were not aware of at the time they signed it. I'll just repeat your comment so everybody can hear it. It looks to you like maybe it's going the other way, that it's opening a door that may not have been opened before. Did I accurately repeat? And I'm not sure I disagree with you. I don't believe the intent of the law was to require a statement in the contract about additional large capital investments when the contract does not require any. I believe the intent of the law was that if there's a clause in the contract that you could be required to make additional large capital investments, then yes, they wanted that disclosed up front, so it was not a surprise to the contract producer. But requiring it to be stated on the first page of the contract when it is not a provision of the contract, I do not believe was the intent of the law, and it was a surprise to me when the Packers and Stockyards Administration took this approach. So, but what I've done and everyone else has done is to put that clause, that disclosure statement on the front to protect the party from any possible enforcement action by the Packers and Stockyards Administration. And what was the effect of that? What I just told you about. The other party reads it and says, holy smokes, what's this? We never talked about any of this. So all you can do is assure that party that that is not there's nothing in the contract that requires that. It's a requirement of federal law. Okay? There's also a provision under Packers and Stockyards about the choice of law and venue in marketing and production contracts. This is pretty much a law that tells you where the legal forum will be in the federal judicial district in which the principal part of the production takes place. It's nothing you have to do differently in a contract. This is a provision of federal law that, and the contract may specify which state law applies. And many contracts do. If you're dealing with a party that's out of state, that contract will say X law applies versus the state you're in. And the contract can do that unless it's prohibited by individual state law. And I'm not aware of any state that prohibits it. I better be careful saying any state. I know Iowa law does not prohibit such a clause in a contract. Arbitration. Many contracts have an arbitration clause in them. Instead of going to court, you use the arbitration provisions or arbitration process, I should say. What the federal farm bill said under Packers and Stockyards Administration now is that any contract requiring arbitration must contain a provision allowing the producer, before entering into the contract, to decline to be bound by the arbitration provision. And this applies not only to production contracts, it applies to marketing contracts, the Packer contracts. Plus, this is being interpreted to apply to any livestock contract. So a wean pig purchase agreement could be subject to this. So, what I would tell you, if you're working with a contract that has an arbitration clause in there, and it deals with livestock in any way, shape, or form, this clause needs to be in there to give the other party to the contract the right to decline it, to be bound by that, before they enter into the contract, and it must conspicuously disclose the producer's right to decline the arbitration. A little bit more on that in a second. As we, at this slide, we talk about the Packers and Stockyards, USDA, is to issue regulations on these requirements in the Farm Bill and a couple of other areas. The arbitration clause I just talked about, and they are to issue regulations on whether an undue or unreasonable preference or advantage has occurred in violation of the Packers and Stockyards Administration regulations due to contracting. Okay. Also, they're to issue regulations on the additional capital investment requirements and whether a contract feeder has been given a reasonable period of time to remedy a breach of contract that could lead to a termination of the contract. I tried to quote the law as close as I could on these slides because it's pretty detailed on what Congress wanted additional regulations from the Packers and Stockyards Administration on. And as you can see on the first line or second line there, these regs are to be issued within 2 years. It's my understanding that they are close to coming out and should be coming out any time in the next month or so. But we were supposed to have them before the end of the year, and we haven't seen them yet. There have been regulations issued on poultry contracting, and I won't go through those today. But the swine contract regulations, as I'm talking about here, should be coming out any time. When they do, we will get those out to you as soon as we can through maybe something on our website or somehow get the notice out to you, and they will be open for public comment. This thing's moving without me doing anything, I think. But all right. Any questions on the contracting requirements? it's a critical issue. I really can't emphasize it enough, because what we're seeing is an active enforcement program by Packers and Stockyards Administration. If you have specific issues on this with your contract, please talk to your attorney, talk to the other party to the contract, or I'll be around afterwards. I'd be glad to visit with you about any more details I can give you. Okay, now let's talk about liens for a minute. We've got about 15 minutes left. And again, as I talked about at the beginning of this presentation, when you talk about one party filing a lien, there's always another party that lien was filed against. And I know I have people in this audience who are on both sides of the issue. The way I look at a lien, and you can tell me if I'm wrong, but I look at a lien as just a practice of doing business. As we all know, when you borrow money from a source of financing, bank, farm credit, whoever it is, when you borrow money there, they loan it to you, they take a security interest and file a UCC1 on the collateral for the loan that you just took out. They don't wait to see if they think you can pay it back or if there's trouble coming. They do it as a matter of doing business. The question for you, as pork producers who may own pigs, as pork producers who may be feeding somebody else's pigs, do you want to do that as a matter of doing business to protect your right to payment? If you're a bank or other source of financing, the question is, do you want your customers doing that, who you are loaning money to, maybe to put up buildings to contract feed hogs, or that you're loaning money to you're financing those pigs that are going in someone else's building? Whatever lien I talk about here, there's always two sides to it. There's somebody who is who's protecting themselves, and there's more than two sides usually. There's the two parties to it, and then there's the financing sources for both sides. And I can give you examples, and like anything else, where one party is advantaged, the other party may be disadvantaged. So all I want to do today is lay out your options. I want you to make your own decisions. But one of the things I've learned in the last year or so, there are calls we don't like to get, but one of the calls I hate to get is from a contract grower who says, I'm not getting paid for feeding someone else's pigs. I haven't been paid for a couple months now. What can I do? It doesn't look like I'm going to get paid. I've been working with the other party. I know they're going through tough financial times, but I need to be paid. I can't make my loan payments. And then I ask, have you filed a UCC1, a lien? And if the answer is no, then it really cuts down on the chances of you getting paid. Okay? Let's go through this. A landlord's lien first is where, in the hog production situation, would be where, let's say I own the buildings, and you're going to put pigs in my building, and you're going to take care of them. All I'm doing is renting it out to you. I'm not providing the feed and care for those pigs. I'm not doing anything other than renting it to you, and you're paying me a monthly payment. That's where you would file a landlord, what we call a landlord's lien, and you, let's see. I want to point this out. You must file a UCC1 within 20 days under Iowa law after the tenant takes possession of those premises to have priority over other UCC1s. So the key is get it filed within 20 days. And on this UCC1, it must include a statement that it is filed to perfect a landlord's lien. That's the only lien we have in Iowa law where you have to put a specific statement about what type of lien it is. So if you own buildings or if you're a tenant renting buildings, it's key if this UCC1 is filed that it has that statement on it. Another point, sometimes people think, well, why would a tenant want a landlord to file a lien against them for payment, the rent on the hog buildings? Contract grower, no matter what it is. I've been through a few of those situations where nobody feels worse when financial difficulties occur than the person who can't make the payments to someone they owe money to. And I've had several owners of pigs and tenants who are renting hog buildings say, I wish I would have encouraged my landlord or the person who's contract feeding my pigs to file that lien to protect themselves, because now they're not going to get paid, it doesn't look like, and I feel terrible about that. So again, there's a lot of different sides to all this, and sometimes people end up where you may not think they would be. If you're filing a landlord's lien, and this is different than a UCC1 filed by banks, but if you're filing this lien, the same as for a contract grower's lien, if those hogs are going out of state before they're slaughtered, and if you haven't been paid yet, you need to file in that other state. Okay? This is a surprise to a lot of people, but for these types of liens, you have to, quote unquote, chase the collateral. So if it's going to another state, or if it's crops, if it's corn, and you're the landlord and you haven't been paid, you need to be filing your UCC1 in another state if that's where the collateral is going to. I want to talk about the third bullet point there. This filing, and this is a question I often get, for a landlord's lien or a contract grower's lien, this filing does not result in the landlord's name being on the packer check unless other steps are taken. So you can file a UCC1 and your name won't end up on the check for those pigs, or if it's crops, whatever, won't end up on that check. Again, it's part of the concern on these liens is the other party of the lien says, well, okay, I understand you have the right to do this and I'm okay with that, but we can't have your name on my check because that causes all sorts of headaches. Again, it doesn't happen unless you take steps to put it there. So just filing your UCC1 will not result in your name being on their check. These liens that I'm talking about here are liens provided by law. So the first step, that is having a signed security agreement, you're not required to do because you have a lien by law. The law gives you that lien. So, no, you don't have to have a signed security agreement or anything like that. You have to have a contract. You have to have a legal right to payment. But then Iowa law says you get this lien, and what you need to do to, quote unquote, the law uses the term perfect. What you need to do to perfect that lien is file it. But you don't need a signed security agreement to start with because the law gave you the lien. On this slide here, for your production contract lien, you have to file it to have any right to payment under this lien. You have to file it within 45 days after each group arrives. Okay? Unless you're a nursery with continuous arrival, that is more than monthly deliveries, more frequent deliveries, then you have 180 days. But I assume most people's situation is a typical either wean to finish or feeder pig to finish. So when that group of pigs comes in, you have 40 days to file the lien. 45 days, to file the lien. That's the first step, okay? You get that on file within 45 days. Then you haven't been paid when it's due, and maybe it goes another month, and you haven't been paid. If you've filed it within the 45 days, then you can notify the packer and say, I want my name on the check because I haven't been paid. But I'd put a step in there first. Be in touch with the other party, which you probably have, and said, hey, where's my check? What's going on? Try to negotiate with them. But if you haven't been paid, notify the packer to have your name put on the check with a copy of your lien that was filed within the 45 days. If you miss the 45-day period, how can I say this legally and because I'm on tape? You're screwed. I mean, you missed the deadline. And that's the call I hate to give for contract growers because, now you can go ahead and file it. I think I state that on the slide. But you don't have priority. What you want is priority over the other creditors. All you want to do is get paid for what you've done, for the services you've provided, and that's what this lien gives you, but you have to file it within that period of time. Now, I believe you also, you also asked me about now they go to another state, you don't know where they're going, you don't know which packer to notify. That's a tough one. You have to just try and track it down. But just because you haven't notified the right packer doesn't mean you don't have a right to those proceeds of sale, okay? It just means your name's not on the check, okay? You still have a right to those proceeds. You just have to you have to track them down. And I'm probably really getting into an area now where you need individual legal advice for that. But I'll emphasize it again. The key is to get the UCC1 filed on time. Don't miss your 45-day period. Okay, yes, sir. Yes, I think you all heard that. That's exactly what I'm telling you. Each group of pigs needs a new UCC1 filed. The question was, by doing what I just talked about, gives the contract grower priority over the lender of the owner of the pigs? That's correct, if it's done within 45 days. Now, for some of you pig owners out there or lenders to pig owners, I've gotten calls from people who say, boy, isn't that going to hurt the ability to get financing, etc.? And again, I'll stay out of that debate if I can. The point is, it gives that producer priority right to payment, but only for the payments on that group of pigs. And again, it's for the amount that's owed. And what should that contract producer do when they're done and they've been paid and that group of pigs is gone? And I have a slide on it. File a termination statement so that lien is shown that it's been terminated. You do it with the same process. That one costs $5 online, $10 if you send it in. But terminate that lien so that it shows that you were properly paid and everything has been taken care of. Okay, now there was a hand over. There's one there, and then I'll get yours. The question is, what have I seen as far as how does filing a contract grower's lien affect the relationship between the contract grower and the integrator or the owner of the pigs? I've not seen any real problems, but maybe I wouldn't see those between the two. I know there are some owners of pigs that don't care, that would prefer that contract growers not do that. There are other integrators and contract owners of pigs, as I told you, actually encourage their contract growers to do it. They want to make sure they get paid, okay? I don't think, and I come back to this is doing business. You're, in a way, when you're the contract grower, you're like the bank. You're providing something and haven't been paid. You'll be paid monthly, etc., but you haven't been paid yet. If you want to protect your right to payment, this is something you can do. It's not that you don't trust the owner of the pigs. It's just a matter of doing business. That's the way I look at it anyway. You may look at it differently. But if it's done correctly, and if you are properly paid, and you terminate that UCC1, then everything's fine. If you're not paid, something goes wrong with that owner of the pigs, you are in it's a night and day between your legal position without filing the contract grower's lien versus filing it within 45 days. I don't know. Are there any, if anyone, I'd like to invite some discussion here. I know we're past our 10:30 time period, but we don't have anybody else coming into the room right now, so I'll be glad to talk. What are other people's thoughts? If you're an owner of pigs, how do you feel about somebody filing a contract grower's lien? The question was, is there any notification by the Iowa Secretary of State to the person you filed the lien against? And the answer is no, there is not. Yes, what can be done, and I'm not going to do it because I don't want to pull anybody's name up here. Go to this website I showed you. Let's go back here. And you come up here to Business Services, which I have here. See that link there that says Search Databases? You go to that one. And then you get this window. Here's UCC certified. You pull that window up and you type. The way to find out if a lien has been filed against someone is to type a name in there. Okay? And again, I'm not going to do any. Let's just do this one. Okay? Once you've been paid on that group of pigs, everything you were owed for taking care of those pigs, then you file a termination statement. And let's see if I can, I don't want to take too much time. It's a form that if you're doing online filing, it's there. It's the same form that you file for termination amendment. It's a UCC3. Okay? I think once you get a chance and play around with this website, it is a very good website, and you'll be able to find these things. If you have any questions, please feel free to get a hold of us. I know I'm running over my time here, but I think we've covered some very critical issues here. Do you have a question there? Yeah. That's correct. The question was, let's just follow it through. You're feeding pigs. You get a group of pigs. Within 45 days, you file the UCC1, right? Everything goes fine. You're paid. The pigs are marketed. Then you file a termination statement. But you've probably have a group of pigs in there for the next group. You should file that UCC1 within 45 days. In the way it's worked for the clients I've worked with, who some don't do it. Some decide not to, some do. The ones that do, who do enough of it, they get the online filing, get an account set up, get a password, do online filing. And I can almost guarantee you do a lot of book work that takes longer than this. It's just something put on your calendar, and we all have these electronic computer calendars now that give us notice of so many days. I also work with quite a few cattle feedlots which can do this also, and they're getting cattle in, probably, I know some of you pork producers have multiple sites, but cattle feedlots get cattle in and out, and they have to do it for each group of cattle, even in the same feedlot. And they just tell me if they get it in their bookwork and they just start doing it as a matter of business, it really becomes just part of doing it, and it really isn't that much hassle. Okay. Yes, sir? Yes. The question was, is there a lien called a thresherman's lien? I don't have a slide on it. It's now called a harvester's lien, and it can be filed by anyone who is, for combining corn, any harvesting of crop. They can file a lien to get paid. It's a pretty short time period to get it filed after the crop has been harvested. Selling feed? Okay. The question was, does that also apply to an elevator? I believe selling feed? No, that lien does not. The lien that applies to that is an ag supply dealer's lien. You have a slide on it where, and I don't know if we have any feed suppliers here, but there's a lien that the feed suppliers can file. They have to do it within 31 days of the purchase. It's similar to as far as filing the UCC1. Now that lien it's got a lot of nooks and crannies to it. There's a real question. They have an extra step that some believe they have to do, some believe they don't, and that's sending a letter to the secured lender of the pig owner at the same time or before they file the UCC1. And I have, see that last bullet point there? Says the ASDL, Ag Supply Dealer's Lien for Feed. Law is not clear as to whether letter to secured parties is required to have priority over earlier perfected lien or security interest. Safest course of action, send the letter. I'm sorry I'm rattling right through this, but if any of you are using the feed lien, I would strongly encourage you to work with an attorney on that and find out the ins and outs of that law. But they do have a lien they can file, a UCC1, and for feed they have supplied, and they do it very similar to this, how I showed you. For under the collateral line, they list all dead or swine located at a certain premises. Okay? That answer your question? Okay. There's also a veterinarian's lien. And that lien must be filed within 60 days of treating the livestock. So, let's see. I want to get to this point, and then I'll probably wrap it up. I think we're about 15 minutes over, but we've had good discussion here. And again, I'm willing to stick around as long as you have questions or want to talk. Let's see. Let's go back. I talked about the veterinarian's lien. I want to talk now. I've talked about the contract grower, the landlord, the veterinarian filing liens against pigs. What about the owner of those pigs protecting themselves from what happens when I put my pigs in somebody else's buildings? And let's talk about a South Dakota case from 2004. It involved cattle. Company in Minnesota owned the cattle, leased them to an individual in South Dakota. That individual in South Dakota turned out to be, let's say, just less than a reputable individual. That individual in South Dakota leased the cows, didn't own them, leased them. Normally when you own something and put it in somebody else's care, you don't have to file a lien because you own it. You're not providing financing, you own it. So you don't have to file a lien, it's yours. Well, the law gives the right of somebody who, if I own something and I put it in your care, I better turn this around and make me the bad guy. You own something and you put it in my care. What tells my bank that that's not mine, that it's yours? Nothing. Unless you file the owner, and let's get back to my case in South Dakota. The company that owned the cattle in Minnesota leased them to the guy in South Dakota. The guy in South Dakota then pledged them, granted a security interest in those cows to his bank. His bank in South Dakota looks at the filings in South Dakota and sees nothing. Nothing about those cows. So they thought, we're good. Well, as you might suspect, the whole deal went sour, and the company in Minnesota says, hey, we're going to go get our cows, and I'm obviously simplifying this a great deal. The bank in South Dakota that had a security interest in all of the collateral of the individual said, hold it, those were we don't own those cows, but we have those as collateral. And the company in Minnesota says, you're crazy. We own those cows. Court said, company in Minnesota, you lose because you didn't do a protective filing. You didn't file something that puts the world on notice through the Secretary of State's office that those are our cows. And what should have been done, according to the court, and so I guess, what you need to look at here, if you're putting your pigs in somebody else's buildings, and I'm not saying you have to do this every time, and we don't have an Iowa case on it, but to protect yourself, right here where I described, if you were you'd go ahead and describe the swine, okay, and then you'd come down here, and then you'd say, I should have typed this in ahead of time, but you'd say, the swine described herein is the subject of a lease between the debtor and I, and we are filing this for informational purposes only. The key is to state in there for informational purposes only, that you're telling any other secured lender or anybody reading these online records that those pigs in that building at that address are ours, and we're telling you that. Then, if there's ever any question about whose collateral they are, you have put the world on notice and you should be in good shape. So that's an example of a UCC1, a lien filing that can and in many cases should be done by the owner of the pigs versus the contract feeder. Okay? As you probably are coming to the conclusion, there's a lien for everyone in many cases. Not everyone, though. Termination, I talked about that. Here's what the law says about termination. You must terminate any lien within 20 days after you've been notified by the other party to terminate it. Okay? So if you file the contract growers lien, you're paid for everything you're supposed to do, but you leave it sit there, and the secured party, the people you're feeding, or the debtor in this case, the people you're feeding hogs for, send you a letter and say, I want that terminated within 20 days. You have to do that by law. My point is, in the second bullet point, it's just good policy, and you should do it this is a valuable lien for everyone, and to maintain your relationship with the owner of the pigs, terminate it. Terminate it when you're paid, and you show you're treating it as a business, you're doing what you're supposed to do, and therefore you cause the least amount of disruption, I believe, for the other party to the lien. Okay, I have a few other slides here on what if you sell something and don't get paid? Another one of the common questions I get is, I'm selling pigs, I haven't been paid. Those are still my pigs, right? Because they haven't paid them. My contract says you don't get legal title till you pay for them. I want to go get them, or whatever you want to talk about here. As you might suspect, the way I'm pausing here, that's not what the courts say. The courts say once those pigs are in the hands of that new buyer, you may have priority as to that buyer because they haven't paid you. But that buyer's lender now has priority over you because that buyer's lender, if they have a security interest, a blanket security interest on the collateral of the buyer, and there's enough cases out there, I don't even have to cite you, that they are all over the place that say that lender gets priority over you, the unpaid seller. Doesn't seem right, does it? But that's the way it works, and the courts have said that routinely. So, what can you do? Really, three options here. Here's an option I didn't put up there because I don't like to sound like a smart aleck. Get paid ahead of time. But seriously, when things are getting tough and you're selling something to other people, and if you're really, people will ask me, what's the 100% way, sure way I can have of making sure I get paid? And get cash in hand up front. That's about the only 100% way I can give you. What are the other ways to try and make sure, give yourself priority to payment? You can do what's called, file a UCC1. You have to have a security interest in your contract, and then get a subordination agreement from the buyer's secured lender. You would want to do that all up front. I don't know too many buyer's secured lenders who are probably going to be real anxious. I can see a few people smiling at me. They're probably going to say, yeah, right. Okay, number 2. Get your security interest in the contract and then file what's called a purchase money security interest, where you send a letter to, you get your UCC1 filed. I'm the SAL unit. I'm selling pigs under a long-term contract with a buyer. I file my UCC1 that says I'm taking a security interest in those pigs that I'm selling, and then I send a letter to the lender for the buyer that says I've taken a purchase money security interest in those pigs, and you have to do it before the livestock is delivered. If you do that, if all your ducks in a row there, then you have priority over that lender. And then something that some people use is a letter of credit from the buyer's lender, and I'll see if I get the same reaction to that from some people. Okay. I'm not going to get into prepaying. I'll leave that slide for your reading. I'm a little off subject there, but I thought it was worth putting in the slides. I want to end, and this is not on liens now. I've kind of switched back, but this is my standard. People, please call your insurance agent. And I don't have any money in any insurance company, and I don't have a relative who's an insurance agent that I'm going to refer you to. If you are contract feeding, if you're feeding pigs for someone else, and again, this fits under one of those calls I hate to get, it's if something happens to those pigs in your building, and it can somehow be attributed to your negligence, you call your insurance agent up after that happens. A classic example I have is death loss. That one client I had was working on the building, shut the breaker off, and just got interrupted, whatever, didn't turn the breaker back on, a bunch of pigs die. Called the insurance agent, and the insurance agent says, ooh, I don't know, I don't think you have coverage here because of what's called the care, custody, and control exclusion under your standard farm liability insurance policy. Not the thing you want to hear at that time. My goal or my point here is, if you're contract feeding, you've got someone else's pigs in your building, please talk to your insurance carrier. Many of you have done this, I know. Talk to your insurance company. Tell them you're contract feeding. You're feeding somebody else's hogs in your building, and make sure you have coverage if something happens to those pigs. Okay? If you don't, there are policies that provide that. If you find out you don't have coverage and you're not worried about it, that's fine, but the time you should find out is then, not later when you have a loss. Okay? I know that was a little off the subject, but I always want to cover that under contract fees.